Hi, this is your professor, Judy Paparosi again, Professor Paparosi to all of you. Now we are going to talk about how to brief Supreme Court or SCOTUS cases. When I started law school and I was looking at all of these cases that I had to brief, which means make an outline of, for each of my 4 classes every night. I went to school at night while working full-time in the New Jersey prison system. It was overwhelming until someone taught me basically how to brief the cases. And it's kind of like skim reading them, but with an outline. And I provide you with a template, which is an outline of how to do this in your course documents. And we'll be doing these together as a class on the discussion board before I expect you to turn your first one in on January 22nd at 5 p.m. Okay, so there are 5 parts to a case brief. And of course, the first thing you should do before you do the 5 parts is put the name of the case as you see it on either what I've provided in the Safe Assign area, or you can find it on the internet by Googling it, okay? And you'll also get a case citation. And each citation, because these are Supreme Court cases or SCOTUS cases, Supreme Court of the United States cases, the middle 2 letters will be U.S. for U.S., meaning the U.S. Supreme Court. And then it'll have a number before it, number after, and then the year. So put the case name and the case citation at the top. Number 1 are the parties. And the parties are a little bit more difficult to do unless you really understand how a case gets itself to the Supreme Court. And it can go in 3 different ways, but we're only going to talk about one way today, which is the most common and most direct way, and the way that most of these cases that we'll be looking at this semester were done. Okay, so number 1 is the parties. The way a case gets to the Supreme Court is there's a lower court decision, which is the trial court and often called the Superior Court. And that's where the trial takes place for felonies, not misdemeanors, which are things that are tried in some kind of municipal or district court, depending on the state you're in. So for those people who work in North Carolina, you think everybody does what North Carolina does. I used to think everybody did what New Jersey does. But no, all over the 50 states, there are different names for different courts. But basically, the trial court or the Superior Court is the name for where the felony criminal case is tried. If there is, of course, most of the cases that we see are not plea bargains because plea bargains are rarely successful in appeals. So somebody is tried for murder, for example. He is tried in a trial or superior court in a state. Now, it can happen in the federal government, but we're not looking at that this semester. But we'll talk about it, but the cases that we're looking at were all state cases that work their way all the way to the SCOTUS. So a person is tried, and he may have raised a constitutional issue like a motion to suppress evidence, which is a violation of the 4th Amendment if the evidence was seized unconstitutionally or illegally by the police or an agent of the police. So say a person is being tried for murder, but he's trying to suppress the gun, saying the police seized it without probable cause. Okay, so before trial starts, there'll be a motion to suppress. And then the person will either win or lose it. If he wins it, that may end the case because if the gun's thrown out, it could be very damaging to the state's or prosecution's case. But just say he lost his motion to suppress on a constitutional issue, obviously search and seizure, and he goes to trial and is found guilty. Then the defendant can appeal. But while he's in the trial court or the Superior Court, as I said, he is a defendant. Okay? Now, the opposite of a defendant is a plaintiff. And in a criminal case, a prosecutor is always the plaintiff. That's the moving party. That's the person who's bringing the case to court. And so the 2 parties in a trial court are the defendant, that is the criminal, and the plaintiff, who is always the state. Or you can say the prosecutor, but most of the time the state. Okay, you would state of North Carolina, state of New Jersey, state of Pennsylvania, etc. Okay, so the first name would be the defendant's name, and the second name would be the state of North Carolina as the plaintiff. All right, that's the trial level parties. But if a person loses in trial court, he's going to be appealing to an intermediary court called an appellate court. Not the top court, not the Supreme Court, but the appellate court. And different intermediate appellate courses across the country have different names. So let's just use the one in North Carolina and just call it the appellate court. Okay, the Court of Appeals, whatever they call it here in North Carolina. And so that intermediary means not the top, it's the middle one, hears appeals from the trial courts in North Carolina. However, the defendant is no longer a defendant at this point in name because he's appealing. He is called the appellant. So the party name in the intermediate appellate court is called the appellant. And the opposite of the appellant, the person who has to respond to his appeal, is either a respondent or an appellee. And that's always going to be, usually going to be the state. Every once in a while, the state appeals, but not after a not guilty verdict, but after losing like a motion to suppress. If the state lost on a motion to suppress, the state would then appeal it if it chose to. Okay. So in the intermediary court or intermediate appellate court, you have an appellant, who's usually the defendant down below in the trial court, and an appellee or respondent. I don't care which word you use as long as you understand it. And that's going to be the state of, in this case, North Carolina. If the defendant loses, the defendant appellant loses in the intermediate court, he'll take his case to the Supreme Court of the state that he was tried and convicted in. Okay, so that's the third step up. So now he's in front of the North Carolina Supreme Court, who will hear appeals as it chooses to. Now, interesting about Supreme Courts, not all Supreme Courts hear what we call appeals or direct appeals. A death penalty case is immediately skips the intermediary court and goes directly to the state Supreme Court. But that's the only kind of case that has an automatic right to be heard by the state Supreme Court. The Supreme Court can choose to have a person petition and present his argument that he should be heard in front of a state Supreme Court. And sometimes you see things like writ denied or cert denied, and it basically just means that the court doesn't want to hear the case. It's more likely to happen in the U.S. Supreme Court, the SCOTUS, but can also happen in state courts. But let's just say somebody appeals to the Supreme Court of North Carolina, and the Supreme Court of North Carolina agrees to hear the case. Again, the person is an appellant in the Supreme Court of North Carolina, and the state, as the prosecutor, is the respondent or the appellee. Now, say he or she loses his or her case, in the Supreme Court here in North Carolina. If there is a constitutional issue, like I mentioned, a Fourth Amendment or Fifth Amendment issue that is really pressing in the case, the U.S. Supreme Court, SCOTUS, may decide to hear it. But how the defendant gets into that court is very interesting. He or she has to petition the court to hear his or her appeal. And it's a petition for a writ of certiorari, which you'll see in the discussion on the discussion board and in my template. The certiorari is basically just saying, it's a Latin word that basically says present the documents. And so if the court grants a writ of certiorari, the defendant and the respondent, who is the defendant who is the appellant and the respondent who is the state prosecuting him, have to present its arguments and its paperwork before the Supreme Court of the United States. And 4 judges or 4 justices on the U.S. Supreme Court, the SCOTUS, it's called the Rule of 4, must decide whether or not to accept or reject that case. Now, the 5 cases that we're looking at, the Rule of 4 justices said, we are going to hear this case because we want to clarify what the court's position is in interpreting the Constitution on these constitutional issues like the right to an attorney, the right to remain silent, the right to be free from unreasonable searches and seizures, etc. So the 5 cases that we're going to look at, we're going to see the parties go from the trial court to the intermediate appellate court to the state Supreme Court and then to the SCOTUS, where these cases were heard and decided and had a major impact on the criminal procedure in the criminal justice system. That's part 1, parties. During the semester, I do most of the parties for you. The only way to do them successfully is to read the case, read where what parties where and who appealed, etc. But I try to make it a little easier for you and do this work for you. But I do a lot of research in order to make sure I present the parties to you accurately. The second part is procedural history, the procedural. How did the case proceed through the courts? Well, obviously, in the lower court, the trial court, the defendant was found guilty. He was convicted. He was sentenced maybe to prison, maybe to probation. That's what happened in the trial court. And that's really what I want to know. What happened in the trial court? Did he file a motion to suppress before the trial? What was the issue that popped up that took his case all the way to the Supreme Court? What was the trial court issue? And by the way, trial courts, you don't change the facts. Even if somebody comes in and says, oh, he didn't do it, whatever, 6 years later. The trial court has a finder of the facts, which is the jury, which very rarely does any kind of appellate court ever overturn. But it's how the judge put the law together for the jury members and how he ruled on certain motions by the defense and the prosecution. That's really what gets appealed. Those questions that were raised during trial about how the trial proceeded and not the facts presented to the jury unless something really prejudicial was presented to the jury. So the facts don't really get changed too much, but what does get or repealed too much, what does get appealed are the rulings that the court made about the facts, okay? Not how the jury ruled, but what the judge allowed the jury to hear, basically. Okay, so the procedural history in the trial court is simple. You recite what happened. The defendant was convicted. The judge sentenced him to prison, and any other issues that were significant in the lower court. The second court, the intermediate appellate court, you'll normally say the defendant appealed based on these grounds, and the court upheld his conviction. Or maybe granted his conviction, but in these cases, the court upheld his or her conviction. Then the same thing happens in the Supreme Court of the state of North Carolina. The court, the defendant appealed. The Supreme Court of, say, North Carolina heard the case and upheld the lower court's decision and the conviction. Then the defendant petitions the SCOTUS for a writ of certiorari. The writ was granted, the defendant appealed, and then whatever happened after that will come out later on, okay? But you don't even have to say what happened, what the holding is, because we'll get to that. So that's the second part, the procedural history. And again, I tend to do a lot of these because they're a little hard. Number 3, we'll look at the facts of the case, and normally those are the facts of the crime. And unless there's a big issue raised during the trial, you'll stick to the facts of the crime. This is always the easiest for my students. So the number 3, the facts, just give me the facts of the crime. Number 4 is the issue before the SCOTUS. What issue, what question did the defendant appellant, or maybe the state appellant, bring to the Supreme Court for the court to decide in this particular case? Now, these are all cases that we do during the semester that had a major impact. So these questions are very important. For example, Miranda, which you all know, Miranda versus Arizona. Should his confession be thrown out as not voluntarily and knowingly given? So that was the question before the Supreme Court in Miranda, and the answer, which is number 5, is the holding. Yeah, this confession is being thrown out, and the case is remanded for retrial because you can't use a confession anymore or anything that came out of it, the fruit of the poison tree. So that's the holding. So number 4 is the issue, the question before the court, and number 5, what's the holding? But 5 has 2 parts. Now, what did the court say? What's its rationale? So holding and rationale are number 5. What was the rationale that the court gave to throw out the confession in Miranda and create this rule of law? Well, basically what the court said is that, the police know people's rights, lawyers know people's rights, but people may not know what rights apply to them. And so the police are in a position where if there's going to be custody and there's going to be an interrogation, a defendant must be informed of his or her rights to remain silent, to have an attorney present during questioning, to have a right to an attorney. Anything said can be used against them in a court of law, etc., the ones that you're familiar with from television. So if there's custodial interrogation, custody plus questioning, the court ruled we have to have the highest safeguards for this kind of very intrusive governmental action, an arrest and an interrogation. And so everyone should be on a level playing field, and we should give someone his rights. So those are the 5 parts of a case brief, and I will give you links to sites where law students have briefed these cases on the internet. Do not copy anything or paste anything into any of my documents. That's plagiarism. I do not allow it. I'll give you a 0 and you have to redo it, or I'll give you a 0 and have to refer you for disciplinary action because I do not allow plagiarism in my class. Think like a lawyer. That's what I'm here to teach you. That's the most important skill I can give you as a former prosecutor, former defense attorney. I've been a public defender. I've been in all parts of the legal system. I've worked in probation, parole. I've worked in prisons for 13 years, but I spent many years as a prosecutor and then as a public defender. And I want to impart the ability to understand the legal system to you while we brief these cases. Thank you.